All right, we are back on the record, now meeting in the presence of the jury. I'm sorry I went a little bit long. We had a number of things to go over, and it took 10 minutes longer than I thought, but I appreciate your patience. Thank you for waiting. The record reflects that all jurors are present, all counsel, the defendant is present. All right, Mr. Carlos, Mr. Watkins, Ms. Barr, you want to call your next witness?
Yes, Your Honor. We call Summer Foster.
All right, Ms. Foster, you've already been sworn in, and you remain, you remain under oath.
Okay.
So you can have a seat up there on the witness stand. All right, and whose witness is Mr. Watkins?
This is water, right?
That is
Okay.
water. That's right. Mr. Watkins, direct examination.
Thank you, Your Honor. Good morning, Ms. Foster.
Good morning.
Your Honor, I'm going to object to the display of the exhibit. There's no question pending.
Well, I'm going to ask a question.
Okay, you can ask a question. Just for the record, this is 180,
Three.
183. Okay, thank you. Go ahead.
Is that you and your mother's GoFundMe page?
Objection compound.
It's my GoFundMe page.
The objection's overruled based on the answer.
On behalf of your mother?
Yes,
How much money were you seeking to get?
$50,000.
Nothing further, Your Honor.
All right, Cross.
Thank you. Can you please display, I believe it's Court's Exhibit 180.
183.
Okay. Thank you. I don't think it was identified. Did you create a GoFundMe page online last week?
I did.
Did you do that after you were interviewed by Court TV?
No, I had made the GoFundMe page after I had spoken with you. That was Friday, so I made it the night before I came in to testify, so that was Monday night was when I created it.
And when you say that you created a GoFundMe page, what is a GoFundMe page?
It's a crowdfunding service to, if you need help with something, like a lot of people do it for medical bills and, say like your car breaks down or something. You ask the public to help you fund some need that you have.
And did you feel like you had a need after finding out what had happened to your mother?
Objection,
Yes.
Your Honor, outside the scope.
Overruled.
Yes, I did.
Now, based upon what you testified to previously and what you, in terms of how you came to learn about what happened to your mother, did you feel as though helping your mother get out of town might be a good idea?
Objection, Your Honor, outside the scope.
Overruled goes to the motive for establishing the GoFundMe page. You can answer.
Yes, exactly.
Did you feel like she needed to be away from her attacker?
Yes.
Did you in fact state that when in the portion where you were requesting anyone who may want to donate to that cause in the post itself?
Yes.
Did you feel like, as you testified before, moving out of state may be a good idea?
Yes.
Now, the fact that you included the request for $50,000, where does that amount come from?
I was thinking about therapy cost, moving cost. Pretty much I was thinking, so the average wage of someone is like $50,000 in a year. So I was thinking to make sure that she is covered for at least a year while she settles and finds a job in the new state. I wanted to make sure she'd be covered.
You testified previously that your mother didn't know that you had come forward to the district attorney's office, right?
She
Outside
did
the
not.
scope, Your Honor.
Uh,
Goes to the motive, Your Honor.
I'll allow it. Overruled.
She did not.
And did she know that you were actually then creating a GoFundMe page?
No, she doesn't know what this stuff is.
So you did this on your own volition, is that right?
Correct.
Did you do it to help your mother?
Yes.
Now, as far as any actual compensation or money paid, have you to date received any money from anyone?
No.
Did you include the fact that when you made the solicitation just out to the community, did you include the fact that you had no intention of attempting to bring any civil action against Mr. Winslow personally?
Yes, I said that in the GoFundMe. I don't recall if I said it on TV. I might have. I don't remember.
When I'm referring to as the solicitation, I'm referring to the posting.
Okay, then yes, I did.
And did you in fact state that you have no intent, that neither you nor your mother has any intention of attempting to get money from Mr. Winslow?
We do not.
Overruled.
Thank
We
you.
do
The
not.
answer will stand.
Thank you, nothing further.
Cross. Redirect.
Yeah. You said on Court TV that you and your husband are already planning on moving, isn't that right?
Correct.
So it's gonna take another $50,000 to bring your mother with you?
Correct.
And you want money for a year's worth of wages, but your mother wasn't employed, was she? She wasn't working at the time of this, was she?
Objection 352 as it relates to the response.
I'm not.
Just hang on.
Okay, sorry.
It's okay. When there's an objection, I have to rule on the objection. The objection is what now?
Relevance in 352 as it relates to the specific employment.
Overruled. You can answer.
Are you speaking at the time of the attack or
Your mother wasn't working at
right now?
She wasn't working at the time of the attack, was she?
I don't believe so.
And she wasn't working now. She's not working now, right?
Well, she has her seasonal job now. Yes.
That started when?
It started on
Your
this
Honor,
Friday.
Objection 352 in relevance.
Well, I'll allow that answer to stand, but no further inquiry as to the type of job.
No. When you originally put this up, you were asking for $100,000, weren't you?
Yes, and then I realized that was way too much money.
And then you took the post down, right?
I did because I was receiving threats online.
Nothing further on.
All right, anything further?
No?
All right, can this witness be excused one more time?
Yes, Your Honor.
Okay, you are excused. Thank you very much.
Thank you.
Have a nice day. Next witness.
We call Officer Jacqueline Pacheco. She's up there.
You should be.
You do solemnly state that the testimony you are about to give in the matter now pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
If you would, please have a seat at the witness stand. And if you would, please state your name and spell your first and last name for the record.
Jacqueline Pacheco, JACQUELINE,
Thank you.
All right. Good morning, officer.
Good morning, Your Honor.
Thank you for being here. Direct examination.
Thank you, Your Honor. Officer Pacheco, how are you employed?
I currently work for the city of Carlsbad in the patrol division from 4 p.m. to 4 a.m.
Okay, how long have you been employed in that capacity?
I've been a police officer for about 4 years. My first few were with a different agency.
Okay, what are your duties now?
In the patrol division, our job is to respond to 911 calls and non-emergency calls. And I go out, I take my reports. I also do some self-initiated police work.
Did you get a call, a non-emergency call to interview who we've been referring to as Jane Doe 5?
I did.
You're familiar with that person?
Yes,
Okay. Did you go out there and interview Jane Doe 5?
I did.
Okay. When you did that, did you have your body-worn camera activated?
I did.
Okay. Did she make a call into the police, or how did you come about interviewing Jane Doe 5?
Detective Johnson came to the Carlsbad Police Department, talked with my sergeant at the time, and said that there was a sexual assault that got reported into a Crunch Fitness, and we responded to her address to go investigate the call.
Jane Doe 5 didn't contact you though, did she? Or
Not
your
me
office?
directly or my department, no.
In fact, she didn't call it into the police, did she?
She did not.
Okay. When you interviewed Jane Doe 5, did you activate your body-worn camera?
I did,
Okay. And you just, I'm assuming you discussed what had happened with her?
yes.
Did she describe to you an incident involving a jacuzzi and another
Objection.
male?
Just a moment.
Leading.
Overall, it's foundational.
Did she describe to you an incident that involved a jacuzzi and another gentleman?
Yes.
Okay. And when she told you, when she described that incident to you, did she describe leaving the jacuzzi?
When
some
she
point?
said she left the jacuzzi, she got out and went to a larger pool.
Okay. What did she tell you happened when she went to the larger pool?
She spoke with her husband.
What did she tell her husband?
She pointed out the suspect who was in the jacuzzi and said he's the one who was masturbating, and her husband identified the suspect as the football player.
What did he say specifically?
I'm sorry, what did he say or what did she say?
What did he say, the husband?
He said he's the football player, the one who has the problem, and they later identified him as Kellen Winslow.
And in fact, while you guys were interviewing them, you asked for a description of this individual, right?
I did,
And the husband, did he interject that he's a tight end?
yes,
Okay, and that's a football position, right?
correct.
Did they inform you that they actually looked him up on the internet?
They said the husband identified him as Kellen Winslow, and she said that she looked him up at some point.
Okay. So they knew him by name, right?
He did.
And this was all before that they had ever even contacted the police, right?
Objection calls for speculation.
Overruled, well, no, sustained.
Again, they never contacted you to come take the report, did they?
Correct. They did not contact us.
Last question, you did a report in this matter, right?
I did.
And when you stated that Jane Doe 5's husband said he's the football player, the guy who has the problem, you put that in quotes.
Yes.
Why did you do that?
During my interview, at times when they say something, I'll write down what they said. I also have body-worn camera footage of the entire interview.
And you put that in quotes because that's exactly what her husband said, right?
That is what I heard, yes.
Nothing further?
All right, Cross.
Thank you, Your Honor. When you spoke to Jane Doe number 5 and her husband, that would be Robert C., correct?
Correct.
That took place on the evening of February 26th of 2019, right?
Yes.
And when you spoke to them, that was after Detective Johnson had at least received some information about the incident and alerted the Carlsbad Police Department. Isn't that true?
Correct.
Now, when Detective Johnson spoke to your sergeant, you weren't necessarily privy to that conversation, were you?
No, I was not.
When he coordinated with you to obtain the statement of Jane Doe number 5, did he brief you, just generally speaking, about what information he had at that point?
He said it was a sexual assault case, and he planned on doing a photo lineup to ID the suspect if the victim didn't know who the suspect was. I myself personally was not familiar with the case. I'm not a huge football fan, so I didn't know really what was going on.
Sure, understood. And when you went there, was she, when I say she, was Jane Doe number 5 surprised to see you at her front door?
She was.
Did she in fact visibly look as though she was somewhat shaken during the entire interaction you had with her?
Yes.
When she was talking to you about what happened, did she get upset repeatedly?
She did. You could see, like, her voice was trembling during the interview, and she was visibly shaking at some points in the interview.
When she was shaking, did she still, at least in response to some of your questions, describe what Mr. Winslow had done on 2 separate occasions?
Yes.
Did she describe the occasion that Mr. Watkins just referred to as being the one in the jacuzzi?
Yes.
And that was second in time, is that right?
Correct.
And then she also described a prior occasion where he had rubbed his penis next to her while exercising on some machines on the 2nd floor, right?
Correct.
Now, when she was describing those 2 occasions, did she tell you about when she told her husband about this?
During the first incident, she said she later told him, it wasn't immediately at the gym. The second incident with the whirlpool, she said she went in the larger pool at the gym and told him while they were still at the facility.
And when she was talking to you about what she remembers telling her husband and when, at that point you were she was also describing who might have actually done this, right?
Correct.
And did she in fact tell you that on the first occasion she had no idea who the person was?
She did not recognize the suspect until her husband identified him by name.
Right, and in fact that took place sometime after the act, correct?
Correct.
And when she was describing, or you didn't ask them how they knew who the suspect was, did you?
They voluntarily brought it up to me.
Right.
They told me from the start that they knew who was their football player.
And you weren't aware of how they came to learn that information or when, were you?
I don't know how specifically they identified him at one point in time in their lives, no.
When you interviewed them on the 26th, that would have been the day after they had reported this to the Crunch Fitness employees, right?
Correct.
And you weren't part of that conversation with the Crunch Fitness employees, right?
I was not.
You don't know whether or not the manager of the branch gave them any information about who had done this, do you?
I did not know about that conversation, no.
And have you ever personally interviewed Brad Moser?
No.
Did you interview Shelley Traub?
No.
So in terms of when they learned that the person who had done this, it happened sometime after the incidents, but then some before when you spoke to them, right?
Correct.
Thank you, nothing further.
All right, any redirect?
Briefly, Your Honor, when you're speaking with Jane Doe 5, she had mentioned that she told her husband after the first incident, right?
Yes.
And at that point, the husband also mentioned that he had seen that gentleman in the locker room, in the guy's locker room, right?
Correct.
Nothing further.
All right, anything further?
No.
Can this witness be excused?
Yes, Your Honor.
All right, did you work last night?
Not last night. I had a half a day off.
Okay, well, go home and get some sleep then. All right.
Thank you, Your Honor.
Have a good day. Thank you very much. Next witness.
The defense recalls Detective John Johnson.
All right, detective, you can retake the stand. You are still under oath. Okay, direct examination.
Good morning again, Detective Johnson. Good morning. I don't think you'll need your whole binder, but
Hope not.
good to bring it anyways. Can you tell the jury if you know how tall is Kellen Winslow?
Based on my research, running his driver's license, standing next to him, I do believe he's a good 6'4".
6'4"? Is that right?
I believe so, yes.
And if you know, can you tell the jury how much he weighs?
I want to say 230, 240 pounds, but I can't be positive on that.
A range between 230 and 240 pounds.
I think that'd be safe.
And that's based on his DMV records?
I haven't looked at those in some time.
But that's his weight to the best of your knowledge?
I think so.
Detective Johnson, did you interview Kellen Winslow on June 14th,
Objection.
2018?
Objection, hearsay.
That answer does not call for hearsay. It's a yes or no question.
Yes.
When you interviewed him on June 14th?
Objection, hearsay in 352.
Let's approach sidebar on the record. That's it. Okay, we're now meeting in the presence of the jury. The last question that was answered by Detective Johnson was as follows. Detective Johnson, did you interview Kellen Winslow on June 14th? The answer was yes. That answer is stricken. The question is stricken. The jury will completely disregard that answer and not consider it in any way. Just treat it as though you never heard it. All right, next question.
Nothing else, Your Honor.
All right, Cross.
Thank you. So according to Mr. Winslow's DMV records, he's 6'4", correct?
I believe so, yes.
And he's 235 pounds, right?
He's up there, yes, sir.
And at the time that you contacted Mr. Winslow, he had some facial hair, correct?
Yes.
On June 14th? Is that right?
Yes.
And the prior week on June 7th, you at least had seen Mr. Winslow, is that right?
Yes, I had.
Did he have any facial hair, if you recall, on that day?
Yes.
And would you describe Mr. Winslow as muscular?
As compared to who?
Well, let's just say, generally speaking, when you're talking about somebody's stature, would you consider him to be a fairly muscular individual?
I think most of our egos want us to think we're muscular. I think he's in very good shape, but when I think muscular, I tend to think about a bodybuilder. Lou Ferrigno would be muscular.
All right, now let me ask you in terms of your knowledge of Deputy Kyle Klein. Are you familiar with that deputy with the
Yes, I
San Diego
am.
Sheriff's Department?
Yes, I am.
How tall is he, if you know? What would you estimate his height to be?
Objection outside the scope, correct.
Sustained.
Now,
And he was here in court, so it's,
thank you.
the jury saw him for themselves.
Have you seen Mr. Winslow's tattoos?
Yes, I have.
Nothing further, Your Honor.
All right, anything further, Ms. Barr?
Yes, Your Honor. Detective Johnson, have you ever seen Mr. Winslow with his head completely shaved?
I've seen a photograph with his head shaved, yes.
And what time frame was that photograph taken?
I don't know, it's on the internet.
Do you think that it was taken within the last year?
I don't know the reference, I've looked it up on Google, and in the images, there's some shaved head photos of him.
Is that the image? You've never personally seen him with a shaved head?
Not to my knowledge.
Thank you.
All right, anything further? All right, thank you very much. You can resume your seat at council table. Any additional witnesses?
The defense rests, Your Honor.
All right, you want to offer 183?
Yes, yes, Your Honor.
Any objection?
No.
Okay, 183 will be received and the defense rests, correct?
Yes, Your Honor.
All right, is there any rebuttal evidence on behalf of the people?
No.
All right, ladies and gentlemen of the jury, you've now received all the evidence in this case. Just so you have some idea to scheduling, I'm now going to read you the law that applies to this case, and then we're going to hear closing arguments. We're not going to hear closing arguments today because there's no way we can get all the closing arguments in by the end of the day, and I want to be fair and not break up the closing arguments. So what I will do now is instruct you on the law. We're probably going to break a little bit early. We might go a little bit into lunch. I have a lot of jury instructions to read to you, and the court reporter will appreciate this. I'm not going to read them fast. So I will read the jury instructions to you. We're going to break for the day, and we're going to come back tomorrow morning at 9 o'clock, and you're going to hear the closing argument straight through. Mr. Owens will go first, then we will hear from the defense, and because the people have the burden of proof, they get to argue first and last, so then he will have an opportunity to present his rebuttal argument tomorrow. But this case will go to you for deliberations tomorrow, all right? So, with that said, I will now read the instructions to you that apply to this case. Just so you know, I'm going to send this entire notebook back with you to the jury room. So don't feel like you have to write everything down because all these instructions will go back with you. So, members of the jury, I will now instruct you on a law that applies to this case. As I mentioned, I will give you a copy of the instructions to use in the jury room. These instructions that you receive may be printed, typed, or written by hand. Certain sections may have been crossed out or added by hand. Disregard any deleted sections and do not try to guess what they might have been. Only consider the final version of the instructions in your deliberations. As jurors, you must decide what the facts are in this case. It is up to all of you and you alone to decide what happened based only on the evidence that has been presented to you during this trial. Do not let bias, sympathy, prejudice, or public opinion influence your decision. Bias includes, but is not limited to, bias for or against the witnesses, attorneys, defendant, or alleged victims based on disability, gender, nationality, national origin, race or ethnicity, religion, gender identity, sexual orientation, age, or social economic status. You must follow the law as I explain it to you, even if you disagree with the law. If you believe that the attorney's comments in the law conflict with my instructions, you must follow my instructions. Please pay careful attention to all these instructions and consider them together. If I repeat any instruction or idea, do not conclude that it is more important than any other instruction or idea just because I happen to repeat it. Some words or phrases used during this trial have legal meanings that are different from their meanings in everyday use. These words and phrases will be specifically defined in these instructions. Please be sure to listen carefully and follow the definitions that I give you. Words and phrases not specifically defined in these instructions are to be applied using their ordinary everyday meanings. Some of these instructions may not apply depending on your findings about the facts of the case. Do not assume just because I give a particular instruction that I am suggesting anything about the facts. After you decided what the facts are, follow the instructions that do apply to the facts as you find them. Do not use the internet, a dictionary, a smartphone, a computer, or tablet in any way in connection with this case, either on your own or as a group. Do not investigate the facts or the law or do any research regarding this case, either on your own or as a group. Do not conduct any tests or experiments or visit the scene of any event involved in this case. If you do happen to pass by a particular scene, do not stop and investigate. You've all been given notebooks and may have taken notes during the trial. Actually, I think all of you took a lot of notes, and one of you needed another notebook. So you have taken a lot of notes. Of course, you can use your notes during deliberations. I always tell you to leave them here when you leave the courtroom, but you can take your notes back into the jury room. Your notes are for your own individual use to help you remember what happened during the trial. Please keep in mind that your notes may be inaccurate or incomplete. In fact, I'm sure they're incomplete because nobody could possibly write down every word that was said, other than the court reporter, during the course of the trial. Now, if there's a disagreement about the testimony or any stipulations at trial, you may ask that the court reporter's record be read back to you. It is the record that must guide your deliberations and not your notes. You must accept the court reporter's record as being accurate. Please do not remove your notebooks from the jury room once you go back into the jury room. At the end of the trial, Manny collects your notebooks, shreds your notes. We don't read them. We don't look at them. They are for your complete personal use only. There's also, I think, this misconception that the court reporter prepares a transcript every day after the testimony. That's not true. Sometimes I get a note asking for all the transcripts to be brought back into the jury room. The transcripts in a trial like this take weeks to prepare, if not a couple of months. So we do not have the transcripts, but the court reporter, if requested, will go back into the jury room and read back the testimony if requested.
Your Honor, I apologize for interrupting. May we approach?
Yes. On or off?
I think you do it all.
Okay. All right. It is alleged that the crimes occurred on or about March 17th, 2018 for counts 1 through 3, on or about May 13th, 2018 for counts 4 and 5, and on or about May 24th, 2018 for count 6, and on or about in between June 20th, 2003 and June 21st, 2003 for counts 7 and 8, and on or about February 13th, 2019 for count 9, and on or about February 22nd, 2019 for counts 10 through 12. Now, the people are not required to prove the crime took place exactly on each of those days, but only that it happened reasonably close to those days. In this case, you heard from several Jane Does. There was Jane Doe number 1 through Jane Doe number 5. This name is used only to protect her privacy as required by law. The fact that the person is identified in this way is not evidence. Do not consider this fact for any purpose. It's only to maintain their anonymity. The fact that a criminal charge has been filed against the defendant is not evidence that the charge is true. You must not be biased against the defendant just because he has been arrested, charged with a crime, or brought here to trial. A defendant in a criminal case is presumed to be innocent. This presumption requires that the people prove a defendant guilty beyond a reasonable doubt. Now, whenever I tell you that people must prove something, I mean they must prove it beyond a reasonable doubt, unless I tell you otherwise. Proof beyond a reasonable doubt is proof that leaves you with an abiding conviction that the charge is true. The evidence need not eliminate all possible doubt because everything in life is open to some possible or imaginary doubt. In deciding whether people have proved their case beyond a reasonable doubt, you must impartially compare and consider all the evidence that was received throughout the entire trial. Unless the evidence proves the defendant guilty beyond a reasonable doubt, he is entitled to an acquittal, and you must find him not guilty. Evidence consists of the sworn testimony of the witnesses, the exhibits admitted into evidence, and anything else I told you to consider as evidence. Nothing that the attorneys say is evidence. In their opening statements a few weeks ago and soon in their closing arguments, which you will hear tomorrow, the attorneys have discussed the case and will discuss the case, but their remarks are not evidence. Their questions are not evidence. Only the witnesses' answers are evidence. The attorney's questions are significant only if they helped you to understand the witness's answers. Do not assume that something is true just because one of the attorneys asked a question that suggested that it was true. Now, during the trial, the attorneys objected to questions and moved to strike answers that were given by some of the witnesses. I ruled on the objections according to the law. If I sustained an objection, you must ignore the question. If the witness was not permitted to answer, do not guess what the answer might have been or why I ruled as I did. If I ordered testimony stricken from the record, you must disregard it and must not consider that testimony for any purpose whatsoever. You must disregard anything you saw or heard when the court was not in session, even if it was done or said by one of the parties or one of the witnesses. Now, during the trial, you were told that the people and the defense agreed or stipulated to certain facts. Those stipulations were marked as exhibits and will go back with you into the jury room. This means they both accept those facts as true. Because there is no dispute about those facts, you must also accept them as true. The court reporter, again, has made a record of everything that was said during the trial. If you decide that it is necessary, you may ask the court reporter's record be read to you, and you must accept the court reporter's record as accurate. Now, if you ask to have a witness's testimony read back, you're going to get the entirety of the testimony, both direct and cross. We can't just pick and choose small portions of the testimony to read back. You have to have the benefit of both sides asking questions, so you'll hear the entirety of the testimony if and only if you ask for readback. And just to let you know, sometimes it takes a while if you're requesting readback. It takes a while for the court reporter to go through her notes. She has to remove any sidebars, remove any objections, and remove any stricken testimony. So if you do send a note out asking for readback and it takes a while, don't think your request is being ignored. It is just being prepared. So you should continue your deliberations while you're waiting. Facts may be proved by direct or circumstantial evidence or by a combination of both. Direct evidence can prove a fact by itself. For example, if a witness testifies he saw it raining outside before he came into the courthouse, that testimony is direct evidence that it was raining. Circumstantial evidence also may be called indirect evidence. Circumstantial evidence does not directly prove the fact to be decided, but is evidence of another fact or group of facts from which you may logically and reasonably conclude the truth of the fact in question. For example, if a witness testifies that he saw someone come inside wearing a raincoat covered with drops of water, that testimony is circumstantial evidence because it may support a conclusion that it was raining outside. Now, both direct and circumstantial evidence are acceptable types of evidence to prove or disprove the elements of a charge, including intent and mental state and acts necessary to a conviction, and neither is necessarily more reliable than the other. Neither is entitled to any greater weight than the other. You must decide whether a fact and issue has been proved based on all the evidence. Before you may rely on circumstantial evidence to conclude that a fact necessary to find the defendant guilty has been proved, you must be convinced that the people have proved each fact essential to that conclusion beyond a reasonable doubt. Also, before you may rely on circumstantial evidence to find the defendant guilty, you must be convinced that the only reasonable conclusion supported by the circumstantial evidence is that the defendant is guilty. If you can draw two or more reasonable conclusions from the circumstantial evidence, and one of those reasonable conclusions points to innocence and another to guilt, you must accept the one that points to innocence. However, when considering circumstantial evidence, you must accept only reasonable conclusions and reject any that are unreasonable. The people must prove not only that the defendant did the acts charged, but also that he acted with a particular intent. The instruction for each crime and allegations explains the intent required. An intent may be proved by circumstantial evidence. Before you may rely on circumstantial evidence to conclude that a fact necessary to find the defendant guilty has been proved, you must be convinced that the people have proved each fact essential to that conclusion beyond a reasonable doubt. Also, before you may rely on circumstantial evidence to conclude that the defendant had the required intent, you must be convinced that the only reasonable conclusion supported by the circumstantial evidence is that the defendant had the required intent. If you can draw two or more reasonable conclusions from the circumstantial evidence, and one of those reasonable conclusions supports a finding that the defendant did have the required intent, and another reasonable conclusion supports a finding that the defendant did not, you must conclude that the required intent was not proved by the circumstantial evidence. However, when considering circumstantial evidence, you must accept only reasonable conclusions and reject any that are unreasonable. As jurors, you alone must judge the credibility or the believability of the witnesses. In deciding whether testimony is true and accurate, use your common sense and experience. You must judge the testimony of each witness by the same standards, setting aside any bias or prejudice that you may have. You may believe all, part, or none of any witness's testimony. Consider the testimony of each witness and then decide how much of it you believe. In evaluating a witness's testimony, you may consider anything that reasonably tends to prove or disprove the truth or accuracy of that testimony. Among the factors that you may consider are the following. How well could the witness see, hear, or otherwise perceive things about which the witness has testified? How well was the witness able to remember and then describe what happened? What was the witness's behavior while testifying here in court? Did the witness understand the questions and then answer them directly? Was the witness's testimony influenced by a factor such as bias or prejudice, a personal relationship with someone involved in a case, or a personal interest in how the case is to be decided? What was the witness's attitude about the case or about testifying? Did the witness make a statement in the past that is consistent or inconsistent with his or her testimony? How reasonable is the testimony when you consider all the other evidence in the case? Did other evidence prove or disprove any fact about which the witness testified? Did the witness admit to being untruthful? And then finally, Has the witness engaged in other conduct that reflects on his or her believability? Now, do not automatically reject testimony just because of inconsistencies or conflicts. Consider whether the differences are important or not. People sometimes honestly forget things or make mistakes about what happened or what they remember. Also, two people may witness the very same event, yet see it or hear it differently. If you do not believe a witness's testimony that he or she no longer remembers something, that testimony is inconsistent with the witness's earlier statement on that subject. Now, if you decide a witness deliberately lied about something significant in this case, you should consider not believing anything that witness says. Or if you think the witness lied about some things but then told the truth about others, you may simply accept the part that you think is true and then ignore the rest. Now, the crimes and other allegations charged in counts 1 through 6 require proof of the union or joint operation of act and wrongful intent. The following crimes require general and criminal intent. Rape by force or fear is charged in counts 2, 4, and 7. Oral copulation by force or fear is charged in count 3. Sodomy by force or fear is charged in count 5. Rape of an unconscious person is charged in count 8. Willful cruelty to an elder is charged in count 11. And battery against an elder is charged in count 12. For you to find a person guilty of those crimes, that person must not only commit the prohibited act, but must do so with wrongful intent. A person acts with wrongful intent when he intentionally does a prohibited act. However, it is not required that he intended to break the law. The act required is explained in the instructions for each crime and each allegation. Now, the following crimes and allegations require a specific intent or mental state. Those are kidnap with intent to commit rape or oral copulation is charged in count 1. Indecent exposure is charged in count 6. Lewd act in public is charged in counts 9 and 10. The allegation of aggravated kidnapping is charged in counts 2 and 3. And the allegation of kidnapping is charged in counts 2 and 3. For you to find a person guilty of these crimes or to find the allegations true, that person must not only intentionally commit the prohibited act, but must do so with a specific intent. The act and specific intent required are explained in the instruction for each of those crimes and allegations. Neither side is required to call all witnesses who may have information about the case or to produce all physical evidence that might be relevant. The testimony of only one witness can prove any fact. Before you conclude the testimony of one witness proves a fact, you should carefully review all the evidence. If you determine there is a conflict in the evidence, you must decide what evidence, if any, to believe. Do not simply count the number of witnesses who agree or disagree on a point and accept the testimony of the greater number of witnesses. On the other hand, do not disregard the testimony of any witness without a reason or because of prejudice or desire to favor one side or the other. What is important is whether the testimony or any other evidence convinces you, not just the number of witnesses who testify about a certain point. During the trial, certain evidence was admitted for a limited purpose. You may consider that evidence only for that purpose and for no other. Now, you've heard eyewitness testimony identifying the defendant in this case. As with any other witness, you must decide whether an eyewitness gave truthful and accurate testimony. In evaluating identification testimony, consider the following questions. Did the witness know or have contact with the defendant before the event? How well could the witness see the perpetrator? What were the circumstances affecting the witness's ability to observe, such as lighting, weather conditions, obstructions, distance, and duration of observation? How closely was the witness paying attention? Was the witness under stress when he or she made the observation? Did the witness give a description, and how does that description compare to the defendant? How much time passed between the event and the time when the witness identified the defendant? Was the witness asked to pick the perpetrator out of a group or a lineup? Did the witness ever fail to identify the defendant? Did the witness ever change his or her mind about the identification? How certain was the witness when he or she made an identification? Are the witnesses and the defendant of different races? Was the witness able to identify other participants in the crime? Was the witness able to identify the defendant in a photographic or physical lineup? And finally, were there any other circumstances affecting the witness's ability to make an accurate identification? Now, the people have the burden of proving beyond a reasonable doubt that it was the defendant who committed the crimes alleged. If the people have not met this burden, you must find the defendant not guilty. Now, you've heard evidence of statements that a witness made before the trial. If you decide the witness made those statements, you may use those statements in two ways. One, to evaluate whether the witness's testimony in court is believable, and two, as evidence that the information in those earlier statements is true. A witness was allowed to testify as an expert and give opinions. You must consider the opinions, but you are not required to accept them as true or correct. The meaning and importance of any opinion are for you to decide. In evaluating the believability of an expert witness, follow the instructions about the believability of witnesses generally. In addition, consider the expert's knowledge, skill, evidence, training, and education, the reasons the expert gave for any opinion, and the facts or information on which the expert relied in reaching that opinion. You must decide whether information on which the expert relied was true and accurate. You may disregard any opinion that you find unbelievable, unreasonable, or unsupported by the evidence. Now, a defendant in a criminal trial has an absolute constitutional right not to testify. He may rely on the state of the evidence and argue that the people have failed to prove the charges beyond a reasonable doubt. Do not consider, for any reason at all, the fact that the defendant did not testify. Do not discuss that fact during your deliberations or let it influence your decision in any way. The fact that he did not testify cannot be discussed at all during your deliberations in the jury room and cannot be considered for any purpose. You have heard evidence that the defendant made an oral or a written statement before the trial. You must decide whether the defendant made any of these statements in whole or in part. If you decide the defendant made such statements, consider the statements along with all the other evidence in reaching your verdict. It is up to you to decide how much importance to give to the statements. Consider with caution any statement made by the defendant tending to show his guilt unless the statement was written or otherwise recorded. Now, the defendant may not be convicted of any crime based on his out-of-court statements alone. You may rely on the defendant's out-of-court statements to convict him only if you first conclude that other evidence shows that the charged crime was committed. That other evidence may be slight and need only be enough to support a reasonable inference that a crime was committed. This requirement of other evidence does not apply to proving the identity of the person who committed the crime. If other evidence shows that the charged crime was committed, the identity of the person who committed it may be proved by the defendant's statements alone. You may not convict the defendant unless the people have proved his guilt beyond a reasonable doubt. If the defendant tried to hide evidence or discourage someone from testifying against him, that conduct may show that he was aware of his guilt. If you conclude that the defendant made such attempt, it is up to you to decide the meaning and importance. However, evidence of such an attempt cannot prove guilt by itself. If the defendant fled immediately after a crime was committed, that conduct may show that he was aware of his guilt. If you conclude that the defendant fled, it is up to you to decide the meaning and importance of that conduct. However, evidence that the defendant fled cannot prove guilt by itself. The evidence shows that another person may have been involved in the commission of the crimes charged in counts 7 and 8, and those are the counts involving Jane Doe number 4 from 2003. There may be many reasons why someone who appears to have been involved might not be a co-defendant in this particular trial. You must not speculate about whether that other person has been or will be prosecuted. Your duty is to decide whether the defendant on trial here committed the charged crimes. The people presented evidence that the defendant committed the offenses of rape by force or fear as charged in counts 4, and sodomy by force or fear is charged in counts 5. If the people have proved beyond a reasonable doubt that the defendant committed one or both of these crimes, You may but are not required to consider that evidence for the limited purpose of deciding whether the defendant acted with the intent to commit rape or oral copulation as required in count 1, which is kidnap for rape or oral copulation. In evaluating this evidence, consider the similarity or lack of similarity between the offenses and acts. Do not consider this evidence for any other purpose other than what I have defined for you in CalCrim Instruction 1191B, which I'll read to you shortly. Do not conclude from this evidence that the defendant has a bad character or is disposed to commit the crime. If you conclude the defendant committed the charged offenses and acts, that conclusion is only one factor to consider along with all the other evidence. It is not sufficient by itself to prove the defendant is guilty of the charged offense. The people must still prove each charge and allegation beyond a reasonable doubt. Now, you have heard evidence that Jane Doe number 4 had consensual sexual intercourse with the defendant before the act that is charged in this case. Those acts are alleged to have occurred on June 20th through 21st of 2003. And you heard evidence that Jane Doe number 4 had consensual sexual intercourse with the defendant before that act that's charged in this trial. You may consider this evidence only to help you decide whether the alleged victim consented to the charged acts and whether the defendant reasonably and in good faith believed that Jane Doe number 4 consented to the charged acts. Do not consider this evidence for any other purpose. All right, now I know this is a long list of jury instructions. I'm going to take a quick break here. We'll take just a 10-minute break. And when we come back, I'm going to give you the definitions of each crime, the elements for each crime that's charged in this case, counts 1 through 12. But I think it's good to take a quick break because sometimes it gets tedious reading these for a long period of time. So we will take a 10-minute break. Please remember the admonition. Don't discuss the case with anybody or form or express any opinions. We'll see you back here in 10 minutes. okay. I think everyone's used to taking 20-minute recesses, right? You have to. Okay. Oh, we're missing 3 actually. Oh, there. Oh, you. Okay. Okay. You took your old seat back from the beginning of the trial, right? You think?
Your Honor, so you said tomorrow will be done and then Wednesday, or deliberations technically will start tomorrow?
Yes, we'll hear the closing arguments tomorrow, and then the alternates are going to be, you can go home after that. The 12 are going to go back.
Probably back on Wednesday then? That's okay.
What is today? Monday? Let's see. Yeah, Tuesday, Wednesday, yes. Unless somebody gets sick or can't finish up, and then you're seated. Yes.
Does the admonition continue for us?
Yes. I'll give, yeah, I will give you an admonition about that, so. Yeah, it's in here. It's in here. It's way in the back, though. Because I only read it to them and not to you. So. I didn't tell him to go to lunch, did I? Okay. That's right. Well, if he comes in with a big bag of food, we'll know that he. Did anyone see where he went? No? Okay.
So are you like a federally appointed judge?
A what?
Are you like an appointed judge, or do you have to run for be a judge and stuff?
Yeah, there's.
Am I not allowed to ask that?
Oh, no, you can ask. There's 2 ways you can become a judge. You can either be appointed or elected.
Right. Which one are you?
It's a long story, but I was both.
What you currently?
I was elected, and then the seat that I got elected to was vacant, so. Right? Reflect the presence of all jurors, and all counsel and the defendant are present. As I said before, I know this can get very tedious and very overwhelming. That's why I wanted to kind of take a little break right here. But now I'm going to define the elements for each charge that's charged in this case. I don't want to suggest that the other instructions I just read to you have no importance. These are the ones that define the elements for you. So the defendant is charged in count 1 with kidnapping for the purposes of robbery, rape, oral copulation, or sexual penetration in violation of Penal Code Section 209B. Now, to prove the defendant is guilty of this crime, the people have to prove 7 elements. All right, there's 7 elements that go into this charge. Number 1, the defendant intended to commit rape or oral copulation. 2, acting with that intent, the defendant took, held, or detained Jane Doe number 1 by using force or by instilling a reasonable fear. 3, using that force or fear, the defendant moved Jane Doe number 1 or made Jane Doe number 1 move a substantial distance. 4, Jane Doe number 1 was moved or made to move a distance beyond that merely incidental to the commission of a robbery or rape or oral copulation or sexual penetration. 5, when that movement began, the defendant already intended to commit rape or oral copulation or sexual penetration. 6, Jane Doe number 1 did not consent to the movement. And 7, the defendant did not actually and reasonably believe that Jane Doe number 1 consented to that movement. As used here, substantial distance means more than a slight or trivial distance. The movement must have increased the risk of physical or physiological harm to the person beyond that necessarily present in the robbery or rape or oral copulation or sexual penetration. In deciding whether the movement was sufficient, consider all the circumstances relating to the movement. In order to consent, a person must act freely and voluntarily and know the nature of the act. To be guilty of kidnapping for the purpose of robbery or rape or oral copulation or sexual penetration, the defendant does not actually have to commit rape or oral copulation. To decide whether the defendant intended to commit rape or oral copulation, please refer to the separate instructions that I will give you on that crime. The defendant is not guilty of kidnapping if he reasonably and actually believed the other person consented to the movement. The people have the burden of proving beyond a reasonable doubt that the defendant did not reasonably and actually believe that the other person consented to the movement. If the people have not met this burden, you must find the defendant not guilty of this crime. The defendant is not guilty of kidnapping if the other person consented to go with the defendant. The other person consented if she 1, freely and voluntarily agreed to go with or to be moved by the defendant. 2, was aware of the movement. And 3, had sufficient mental capacity to choose to go with the defendant. The people have the burden of proving beyond a reasonable doubt that the other person did not consent to go with the defendant. If the people have not met this burden, you must find the defendant not guilty of this crime. Consent may be withdrawn. If at first a person agreed to go with the defendant, that consent ended if the person changed her mind and no longer freely and voluntarily agreed to go with or be moved by the defendant. The defendant is guilty of kidnapping if after the other person withdrew consent, the defendant committed the crime as I have defined it. Now, a lesser included offense of count 1 is just kidnapping, plain kidnapping in violation of Penal Code Section 207A. If you find the defendant not guilty of count 1, kidnapping for rape or oral copulation, you may then consider whether the people have proved the defendant guilty of the lesser included offense of kidnapping. To prove the defendant is guilty of this crime, the people have to prove 4 elements. The defendant took, held, or detained another person by using force or instilling reasonable fear. 2, using that force or fear, the defendant moved the other person or made the other person move a substantial distance. 3, the other person did not consent to the movement. And 4, the defendant did not actually and reasonably believe the other person consented to the movement. In order to consent, a person must act freely and voluntarily and know the nature of the act. Substantial distance means more than a slight or trivial distance. In deciding whether the distance was substantial, you must consider all the circumstances relating to the movement. Thus, in addition to considering the actual distance moved, you may also consider other factors such as whether the distance the other person was moved was beyond that merely incidental to the commission of the robbery or rape or sexual penetration or oral copulation, whether the movement increased the risk of physical or physiological harm, increased the danger of a foreseeable escape attempt, or gave the attacker a greater opportunity to commit additional crimes or decrease the likelihood of detection. The defendant is not guilty of kidnapping if he reasonably and actually believed that the other person consented to the movement. The people have the burden of proving beyond a reasonable doubt that the defendant did not reasonably and actually believe that the other person consented to that movement. If the people have not met this burden, you must find the defendant not guilty of the crime. The defendant is not guilty of kidnapping if the other person consented to go with the defendant. The other person consented if she freely, number one, freely and voluntarily agreed to go with or be moved by the defendant. Two, was aware of the movement. And three, had sufficient maturity and understanding to choose to go with the defendant. The people have the burden of proving beyond a reasonable doubt that the other person did not consent to go with the defendant. If the people have not met this burden, you must find the defendant not guilty of this crime. Consent may be withdrawn. If at first a person agreed to go with the defendant, that consent ended if the person changed her mind and no longer freely and voluntarily agreed to go with or be moved by the defendant. The defendant is guilty of kidnapping if after the other person withdrew consent, the defendant committed the crime as I have defined it. All right, now I'm going to define rape by force or fear. The defendant is charged in counts 2, 4, and 7 with rape by force or fear in violation of Penal Code Section 261A. To prove the defendant is guilty of this crime, the people have to prove 4 elements for this crime. Number 1, the defendant had sexual intercourse with a woman. 2, he and the woman were not married to each other at the time of the intercourse. 3, the woman did not consent to the intercourse. And 4, the defendant accomplished the intercourse by force, violence, duress, menace, or fear of immediate and unlawful bodily injury to the woman or to someone else. Sexual intercourse means any penetration, no matter how slight, of the vagina or genitalia by the penis. Ejaculation is not required. To consent, a woman must act freely and voluntarily and know the nature of the act. It is not required that she physically resist or fight back in order to communicate her lack of consent. Intercourse is accomplished by force if a person uses enough physical force to overcome the woman's will. Duress means a direct or implied threat of force, violence, danger, or retribution that would cause a reasonable person to do or submit to something that she would not do or submit to otherwise. When deciding whether the act was accomplished by duress, consider all the circumstances, including the woman's age and her relationship to the defendant. Menace means a threat, statement, or act showing an intent to injure somebody. Intercourse is accomplished by fear if the woman is actually and reasonably afraid. The defendant is not guilty of rape if he actually and reasonably believed that the woman consented to the intercourse and actually and reasonably believed that she consented throughout the act of intercourse. The people have the burden of proving beyond a reasonable doubt that the defendant did not actually and reasonably believe that the woman consented. If the people have not met this burden, you must find the defendant not guilty. Now I will define the allegation or the charge for count 3. The defendant is charged in count 3 with oral copulation by force or fear in violation of Penal Code Section 288A. To prove that the defendant is guilty of this crime, the people have to prove 3 elements. Number 1, the defendant committed an act of oral copulation with someone else. 2, the other person did not consent to the act. And 3, the defendant accomplished the act by force, violence, duress, menace, or fear of immediate and unlawful bodily injury to someone. Oral copulation is any contact, no matter how slight, between the mouth of one person and the sex organ or anus of another person. Penetration is not required. In order to consent, a person must act freely and voluntarily and know the nature of the act. An act is accomplished by force if a person uses enough physical force to overcome the person's will. Duress means a direct or implied threat of force, violence, danger, hardship, or retribution that causes a reasonable person to do or submit to something that he or she would not otherwise do or submit to. When deciding whether the act was accomplished by duress, consider all the circumstances, including the age of the other person and her relationship to the defendant. Menace means a threat, statement, or act showing an intent to injure someone else. An act is accomplished by force. Strike that. An act is accomplished by fear if the other person is actually and reasonably afraid. The defendant is not guilty of forcible oral copulation if he actually and reasonably believed that the other person consented to the act. The people have the burden of proving beyond a reasonable doubt that the defendant did not actually and reasonably believe that the person consented. If the people have not met this burden, you must find the defendant not guilty. All right, I will now define the elements for count 5. The defendant is charged in count 5 with sodomy by force, fear, or threats in violation of Penal Code Section 286. To prove the defendant is guilty of this crime, the people have to prove 3 elements. Number 1, the defendant committed an act of sodomy with another person. 2, the other person did not consent to the act. And 3, the defendant accomplished the act by force, violence, duress, menace, or fear of immediate and unlawful bodily injury to another person. Sodomy is any penetration, no matter how slight, of the anus by one person by the penis of another person. In order to consent, a person must act freely and voluntarily and know the nature of the act. An act is accomplished by force if a person uses enough physical force to overcome the other person's will. Duress means a direct or implied threat of force, violence, danger, hardship, or retribution that causes a reasonable person to do or submit to something that she would not otherwise do or submit to. When deciding whether the act was accomplished by duress, consider all the circumstances, including the age of the other person and her relationship to the defendant. Menace means a threat, statement, or act showing an intent to injure someone. An act is accomplished by fear if the other person is actually and reasonably afraid. The defendant is not guilty of forcible sodomy if he actually and reasonably believed that the other person consented to the act. The people have the burden to prove beyond a reasonable doubt that the defendant did not actually and reasonably believe that the other person consented. If the people have not met this burden, you must find the defendant not guilty. Now I'll talk to you about count 6, which is indecent exposure, and lay out the elements for that. In this case, there's 2 elements. The defendant is charged in count 6 with indecent exposure in violation of Penal Code Section 314. To prove the defendant is guilty of this crime, the people have to prove 2 elements. Number 1, the defendant willfully exposed his genitals in the presence of another person or persons who might be offended or annoyed by the defendant's actions. And 2, when the defendant exposed himself, he acted lewdly by intending to direct public attention to his genitals for the purpose of sexually arousing or gratifying himself or another person, or sexually offending another person. Someone commits an act willfully when he does it willingly or on purpose. It is not required that he intend to break the law, hurt someone else, or gain any advantage. It is not required that the other person or another person actually see the exposed genitals. All right, now we'll define count 8, which is rape of an unconscious person. The defendant is charged in count 8 with raping a woman who was unconscious of the nature of the act in violation of Penal Code Section 261, subdivision A4. To prove the defendant is guilty of this crime, the people have to prove 4 elements. Number 1, the defendant had sexual intercourse with a woman. 2, he and a woman were not married to each other at the time of the intercourse. 3, the woman was unable to resist because she was unconscious of the nature of the act. And 4, the defendant knew that the woman was unable to resist because she was unconscious of the nature of the act. Sexual intercourse means any penetration, no matter how slight, of the vagina or genitalia by the penis. Ejaculation is not required. A woman is unconscious of the nature of the act if she is unconscious or asleep or not aware that the act is occurring. The defendant is charged in counts 9 and 10 with engaging in lewd conduct in public in violation of Penal Code Section 647A. To prove that the defendant is guilty of this crime, the people must prove 5 elements. Number 1, the defendant willfully engaged in the touching of his own genitals. 2, the defendant did so with the intent to sexually arouse or gratify himself or another person, or to annoy or offend another person. 3, at the time the defendant engaged in the conduct, he was in a public place or a place open to the public or to public view. 4, at the time the defendant engaged in the conduct, someone else who might have been offended was present. And 5, the defendant knew or reasonably should have known that another person might have been offended by his conduct or was present. Someone commits an act willfully when he or she does it willingly or on purpose. Now, as used here, a public place is a place that is open and accessible to anyone who wishes to go there. The defendant is charged in count 11 with elder abuse in violation of Penal Code Section 368, Subdivision C. To prove the defendant is guilty of this crime, the people must prove 3 elements. Number 1, the defendant willfully inflicted unjustifiable physical pain or mental suffering on Jane Doe number 5. Number 2, Jane Doe number 5 was an elder. And 3, when the defendant acted, he knew or reasonably should have known that Jane Doe number 5 was an elder. Someone commits an act willfully when he or she does it willingly or on purpose. An elder is someone who is at least 65 years old. Unjustifiable physical pain or mental suffering is pain or suffering that is not reasonably necessary or is excessive under the circumstances. Now, the defendant is charged in count 12 with battery against an elder in violation of Penal Code Section 243.25. To prove the defendant is guilty of this crime, the people must prove 3 elements. Number 1, the defendant willfully touched Jane Doe number 5 in a harmful or offensive manner. 2, Jane Doe number 5 was an elder. And 3, when the defendant acted, he knew or reasonably should have known that Jane Doe number 5 was an elder. Someone commits an act willfully when he does it willingly or on purpose. It is not required that he or she intend to break the law, hurt someone else, or gain any advantage. The slightest touching can be enough to commit a battery if it is done in a rude or angry way. Making contact with another person, including through his or her clothing, is enough. The touching does not have to cause pain or injury of any kind. Conviction of a sexual assault crime may be based on the testimony of a complaining witness alone. Now, the people have presented evidence that the defendant committed the crimes of kidnap with intent to commit rape or oral copulation as charged in count 1, rape by force or fear is charged in counts 2, 4, and 7, oral copulation by force or fear is charged in count 3, sodomy by force or fear is charged in count 5, indecent exposure is charged in count 6, and rape of an unconscious person is charged in count 8. If the people have proved beyond a reasonable doubt that the defendant committed one or more of these specific crimes I just enumerated, you may, but are not required to, conclude from that evidence that the defendant was disposed or inclined to commit sexual offenses, and based on that decision also conclude that the defendant was likely to commit and did commit the other sex offenses charged in this case. If you find the defendant committed one or more of these crimes, that conclusion is only one factor to consider along with all the other evidence. It is not sufficient by itself to prove the defendant is guilty of another crime. The people must still prove each charge and allegation beyond a reasonable doubt. Now, with respect to counts 7 and 8, this following instruction only applies to these 2 charges. These are the charges from 2003 involving Jane Doe number 4. In order to, there's a special allegation that is attached to count 7 and count 8. In order to find the special allegation true for 7 and 8, the people must prove two things. Number 1, the crime involves substantial sexual conduct, and 2, there is independent evidence that clearly and convincingly corroborates Jane Doe number 4's allegation. Substantial sexual conduct means penetration of the vagina or rectum of the victim by the penis of another or by any foreign object, or a copulation or a masturbation of either the victim or the offender. Now, in this jury instruction, there is a different burden of proof. It's by clear and convincing evidence, which is not as high as beyond a reasonable doubt. You still must find the defendant guilty. That you can only find the defendant guilty of all charges if you find that people have proved the case beyond a reasonable doubt. This clear and convincing element only applies to this special allegation for counts 7 and 8. Clear and convincing evidence is defined as follows. Clear and convincing evidence of the corroboration means evidence of such convincing force that demonstrates, in contrast to the opposing evidence, a high probability of truth of the facts for which it is offered as proof. Such evidence requires a higher standard of proof than proof by a preponderance of the evidence. Proof by a preponderance of the evidence means it is more likely than not that the fact is true. So clear and convincing evidence is a higher burden than clear and convincing evidence, but less than beyond a reasonable doubt. Independent evidence may include evidence of the defendant's sexual misconduct against a separate victim. Such sexual conduct, if believed by you, may standing alone constitute independent evidence that clearly and convincingly corroborates Jane Doe number 4's allegation. Independent evidence is evidence that is separate and apart from the testimony of Jane Doe number 4. Now, as I mentioned with respect to that count, there are allegations that apply to some of the charges. And when you get the verdict forms, you will see, for example, I'll just give you an example. This is the verdict form for count 2. It talks about rape by force or fear is charged in count 2. And there's an area to find the defendant guilty or not guilty of this charge. If you find the defendant not guilty, you're done with this charge. You don't need to worry about it anymore. Only if you find the defendant guilty beyond a reasonable doubt do you then go down and address the allegations that are charged for each charge. So there's the independent charge for each count, and then some of them have allegations that you must determine whether are true or not if you find the defendant guilty of the underlying charge. So if you find the defendant guilty of the crimes charged in counts 2 or 3, you must then decide whether for each crime the people have proved the additional allegation that the defendant kidnapped Jane Doe number 1, increasing the risk of harm to her. You must decide whether the people have proved this allegation for each crime and return a separate finding for each crime. To prove this allegation, the people have to prove 5 elements for the allegation itself. Number 1, the defendant took, held, or detained Jane Doe number 1 by the use of force or by instilling reasonable fear. 2, using that force or fear, the defendant moved Jane Doe number 1 or made her move a substantial distance. 3, the movement of Jane Doe number 1 substantially increased the risk of harm to her beyond that necessarily present in the rape or oral copulation charges. 4, Jane Doe number 1 did not consent to the movement. And 5, the defendant did not actually and reasonably believe that Jane Doe number 1 consented to that movement. Substantial distance means more than a slight or trivial distance. The movement must be more than merely incidental to the commission of rape or oral copulation. In deciding whether the distance was substantial and whether the movement substantially increased the risk of harm, you must consider all the circumstances relating to that movement. The people have the burden of proving each allegation beyond a reasonable doubt. If the people have not met this burden, you must find that the allegation has not been proven. If you find the defendant guilty of the crimes charged in counts 2 or 3, you must then also decide whether for each crime the people have proved the additional allegation that the defendant kidnapped Jane Doe number 1. You must decide whether the people have proved this allegation for each crime and return a separate finding for each crime. To decide whether the defendant kidnapped Jane Doe number 1, please refer to the separate instructions that I have given you on kidnapping. You must apply these instructions when you decide whether the people have proved this additional allegation. The people have the burden of proving each allegation beyond a reasonable doubt. If the people have not met this burden, you must find the allegation has not been proved. There's also an allegation regarding multiple victims for counts 2, 3, 4, 5, and 7. So if you find the defendant guilty of 2 or more sex offenses as charged in 2, 3, 4, 5, or count 7, you must then decide whether the people have proved the additional allegation that those crimes were committed against more than one victim in this case. The people have the burden of proving this allegation beyond a reasonable doubt. If the people have not met this burden, you must find that this allegation has not been proved. For each count charged in this case, it is a separate crime. You must consider each count separately and return a separate verdict for each one. All right, count 1 charges kidnap for rape or oral copulation. As I mentioned earlier, there's also what's called a lesser included offense for that crime. Now, the charged offense, there's a verdict form for the charge offense. It says verdict count 1. There's also a separate verdict form for what we call an LIO, or lesser included offense. So what that means, what I'm going to explain to you right now, is I can only accept a verdict of guilty on the lesser included offense if you first find him not guilty of the greater offense. If you find the defendant guilty of count 1, you leave the second form blank, you don't fill it out. If you find the defendant not guilty of the charged crime in count 1, and only if you find him not guilty are you then to determine whether or not he's guilty of the lesser included offense. Now, this is CalCrim 3517, and when you go to fill out these verdict forms, you might want to take a look at this. When I say CalCrim, CalCrim is just short for California Criminal Jury Instructions, and it says CalCrim on the form. That's what that means. So this is CalCrim 3517. Before you fill out the verdict forms for count 1 and lesser included offense, I'd ask you to take a close look at this, because there's 5 possible outcomes for this particular count and lesser included offense. So, if you all find the defendant is not guilty of the greater charged crime, you may find him guilty of a lesser crime, which in this case is simple kidnap, if you are convinced beyond a reasonable doubt that the defendant is guilty of that lesser crime. A defendant may not be convicted of both a greater crime and a lesser crime for the same conduct. Now, I will explain to you which charges are affected by this instruction. Simple kidnapping in violation of Penal Code Section 207A is a lesser crime to kidnapping for rape and oral copulation in violation of Penal Code Section 209B as charged in count 1. It is up to you to decide the order in which you consider each crime and the relevant evidence, but I can accept a verdict of guilty of a lesser crime only if you have found the defendant not guilty of the corresponding greater crime. For the charge with a lesser crime, you will receive a form indicating your verdict on both the greater crime and lesser crime. The greater crime is listed on a separate verdict form. When you have reached a verdict, have the foreperson complete the form, sign, and date it. Now, follow these directions before writing anything on the forms. As I said, there's 5 possible outcomes. The first one scenario is as follows. If you all agree that people prove the defendant guilty of the greater crime as charged, you write guilty on the blank part for this crime, and you sign and date that return, and then you don't write anything on a lesser included offense form. Just leave it blank. That's one possible outcome. The second possible outcome is as follows. If you all cannot agree whether the people have proved the defendant is guilty of the greater crime as charged, in other words, you can't come to an agreement, unanimous decision, then you inform me only that you cannot reach an agreement and do not write anything on any verdict forms. You just say we are unable to reach a verdict on count 1, and you leave both of these forms blank. The third possible scenario is as follows. If you all agree that people have not proved the defendant is guilty of the greater crime, and you also agree that people have proved that he is guilty of the lesser crime, you were to fill out the first form as a not guilty for the greater crime, And then you fill out the not guilty area on the lesser included offense, and you must not write anything on this lesser included offense form unless you have first written not guilty on this form. So that's the third possible scenario. You following me on this? All right, then now the fourth possible outcome is as follows. That's why I told you you need to read this before you fill out the jury form. The fourth possible scenario is if you all agree that the people have not proved the defendant is guilty of either the greater or the lesser crime, you just write not guilty in the blank part for both the greater crime and lesser crime. All right? And then you're done. Now, the fifth possible scenario is as follows. If you all agree that people have not proved the defendant is guilty of the greater crime, but then you all cannot agree on a verdict for the lesser crime, you would write not guilty on the form for the greater crime. You can probably figure out by now, with this form, you leave it blank, and you report to the court that you cannot reach a verdict on the lesser included form. Now, whenever I tell you that people must prove something, I mean they must prove it beyond a reasonable doubt. Now, when you go back to the jury room tomorrow, you will receive all these verdict forms, and they all read pretty much the same, except the language is different for each form. For example, for count 1, it says, we, the jury in the above entitled cause, find the defendant, Kellen Boswell Winslow II, and there's a blank. Underneath the blank, it says guilty/not guilty of the crime of kidnap for rape or oral copulation in violation of Penal Code Section 209 is charged in count 1. And it has regarding Jane Doe number 1. Now, when you return your verdict, you actually have to write the word or words on this line. You just can't circle guilty or circle not guilty. You have to write the word or words on that line. The foreperson then signs it and dates it, and that's how you complete the verdict form for each count. All right, so that concludes the preliminary jury instructions. We're going to take a break for the day, and we'll see you back here tomorrow morning at 9 o'clock. When you come back tomorrow morning at 9, we're going to go right into closing arguments. As I said before, I don't think it's fair, for example, to have the people present their argument today, the defense present their argument today, and then come back tomorrow and just hear from the people on the very last day before you go out for jury deliberations. And based on the timing, there's no way we can fit them in tonight. Also, it gives both the defense and the prosecution an opportunity to fine-tune our closing argument and make it a little more clear for you to understand during the course of the closing arguments. So again, we'll see you back here tomorrow morning. I want you to be extra vigilant tonight. Make sure you don't watch any news coverage or read any news accounts of this case from any source whatsoever. And have a good night. We'll see you back here tomorrow morning at 9 o'clock. Please be on time. We'll see you tomorrow morning at 9.